We'll hear argument in 19835, Northland Industries against Kouba from Colorado County and the First Court of Appeals District.
May it please this court, Ms. Scout will present argument for petitioners. Petitioners have reserved 5 minutes for rebuttal.
Good morning, Your Honors. This case arises out of an accident on a treadmill. The treadmill was manufactured and sold by Magnum, and Magnum subsequently sold its assets to JHTNA pursuant to an asset purchase agreement. The only issue in this appeal is whether or not JHTNA assumed liabilities for personal injury claims like the one asserted relating to this treadmill in that asset purchase agreement. They did not. First, the express language of the assumption provision only extended to specific written warranties that were for repair and replacement of defective parts. Second, there are express exclusions for liabilities relating to product liability claims. Before we dig into those, I think it's really helpful to have an understanding of the broad overview and structure of this agreement as it applies to product warranty and product liability claims. And there are 5 provisions that are helpful to have our bearings. The first is paragraph 2.5, which is the express assumption provision, which assumed written warranties. The second is paragraph 2.6, which excludes liabilities. It tells us what liabilities are expressly excluded, and it expressly calls out product liability claims as being excluded from those liabilities being assumed. The third provision is a representation and warranty about warranties, the scope of the warranties that were given, and about the history of product liability claims. The fourth is a product liability insurance provision in paragraph 6.2. That provision required JHTNA as the purchaser of these assets to provide product liability insurance for the seller, for Magnum. And that provision at the end specifically says that that is the only obligation that JHTNA will have as to product liability claims. The final provision that's helpful to have in mind is an indemnity provision, and that's in paragraph 8.1. 8.1G specifically requires the seller, Magnum, to provide indemnity for product liability claims. As long as JHTNA purchased the insurance it was required to, if that insurance for some reason failed, then any liability for product liability claims would fall back to the seller, to Magnum, under this indemnity provision. When we look at that scope as a whole, the overarching context of the agreement and framework of the agreement shows that there was an assumption of only this limited warranty claim for repair and replacement, and that anything having to do with product liability claims, the only obligation that was going to fall to JHTNA as the purchaser was to procure insurance. That was it. So with that overall context in mind, I want to look at this specific assumption. The specific assumption is in paragraph 2.5. And when we're looking at successor liability, the question under both Texas and Wisconsin law is, what did the seller or what did the purchaser expressly assume? What obligations? If they did not expressly assume those obligations, they have no liability for those obligations. They stay with the predecessor entity.
The Court of Appeals looked at the assumption by agreement point under the lens or the backdrop of the UCC. Does that change your reliance on the particular language in 2.5?
No, ma'am, it does not. So when you look at the language of 2.5, it makes it clear that the assumption was only for the liabilities specifically identified below. And when you look at those liabilities specifically identified below, paragraph 2.5.6 specifically identifies the liability being assumed as the written warranty. Now, the Court of Appeals is correct, of course, that implied warranty of merchantability is read into a contract for sale. But there's no case law saying that it's read into a specific written warranty. There's no case law that says that. And it would be inconsistent with what the parties did here with the language in their agreement. The language in their agreement is that the assumption is solely for written warranties. And when you look at those written warranties in the Schedule 3.1.17, the written warranty that's provided there in the schedule is very narrow. It is only for repair and replacement, and it's only for a specified time. The frame is a lifetime warranty, the belt is 2 years, there's these specified times, and it's only to the original purchaser.
Where are you, Ms. Scout, where are you relying on that says only for written warranties? Where's that language?
Paragraph 2.5.6, Your Honor.
Any
Says,
product warranty claim set forth in the written warranties. Okay, but what about 3.1.17A that says except as required by applicable law, it's not subject to any warranty beyond the standard terms and conditions?
yes, Your Honor. 3.1.17A, that representation, I think, actually supports the position that the implied warranty is not written into the written warranty. The language of 3.1.17 says, other than those warranties that are implied by law, there is nothing else beyond the written warranty, which means that those implied warranties that are implied by law are also beyond the written warranty. And again, that makes sense with the context here. When you're the purchasing entity, you're purchasing these assets, you agree to assume the liability for this really narrow scope of repair and replacement. That's this small little finite class of claims. To read the implied warranty in that blows that up into these really catastrophic claims like the one we have here, where you have basically unlimited liability. Whereas when you limit that down to the repair and replacement, it's a very small world of things that you are assuming. And it makes sense that that's what the parties would do. I think the other thing that is relevant there in the language of 2.5.6 is it says only with claims arising with respect to and during the time period set forth in the written warranties. The only time periods set forth in the written warranties apply to these repair and replacement warranties. There's not a time period for implied warranty of merchantability type claims set forth in those written warranties. I think that's further evidence that the implied warranty was never intended to be read into the written warranty itself. And when we look at the language here, the only thing being assumed was that specific repair and replacement warranty. And that's further shown by the remainder of the agreement and how it treats product liability claims. Product liability claims in two separate places are excluded from the obligations being assumed by JHTNA. Paragraph 2.6 says, we are not assuming any liabilities for anything that went on prior to closing, including product liability claims expressly, unless it falls within an assumed liability. And when you read the assumed liabilities narrowly to be only that repair and replacement, then that call out for the product liability claims is given meaning, and it excludes liability for those claims. Paragraph 6.2 also makes it very clear in all caps that the only obligation JHTNA has as to product liability claims is to get the insurance that's been required. It says that in all caps. Both those provisions have notwithstanding language leading into them, meaning that they trump other provisions. To the extent there is a conflict, that notwithstanding language means those provisions are going to trump and control.
It's the Court of Appeals, when it looked at 2.6 and 6.2, concluded that you intended different meanings and looked at the fact that there was no limiting language in 6.2. How do you respond to that portion of their analysis as set out in the opinion, and specifically about the interaction between those two provisions?
Well, I think the Court of Appeals, in looking at paragraphs 2.6 and 6.2, really fixated on the definition of product liability claim. And when we do that, I think we need to look at paragraph 6.2 and understand the context in which that definition was being provided. So when you look at 6.2, the context of the product liability claim definition is in context of what insurance was required. They were required to get insurance that would insure Magnum against claims for bodily injury, including death and property damage. Magnum was requiring that they would get insurance for bodily injury and property damage. They were clearly not wanting only insurance if both those things were present. They wanted it for both. They wanted insurance coverage for a bodily injury claim, insurance coverage for a property damage claim, and insurance coverage if both happen to be present. The argument is made that they could have used the word or there. If they meant it to be an either or, they could have used or there. But using or there in the context of this insurance discussion wouldn't make any sense. Because if you put or there, it meant that JHTNA would only be required to provide insurance for bodily injury or for property damage. And if it provided insurance for either, it met its obligation. That's clearly not what Magnum wanted. Magnum wanted to be insured for claims where there is bodily injury, where there is property damage, or where there is both. The context of that definition matters. And it's key to understanding what the parties meant. And it's further evidenced by the fact that the parties clearly understood the term to mean that. When the parties put together a loss run to show product liability claims, they included the schedule of loss runs that included claims where there is only bodily injury. They clearly didn't understand it to be only instances where there's property damage and bodily injury. And that leads to the question, one of the things the Court of Appeals really emphasized was, yeah, but then how does product warranty claim differ from product liability claim? How can they both have meaning? And they both have meaning by constraining a product warranty claim down to the limited language that's in 2.5.6. A product warranty claim is the claim for repair and replacement of a defective part. A product liability claim is a claim for bodily injury or property damage caused by the product. So if it's a claim for just repair or replacement of the product itself, that's not a product liability claim. That's product warranty claim, and that's what JHTNA assumed. But if it's a claim for bodily injury or property damage caused by that product, that is what a product liability claim, and that's the liability that's been excluded. And again, we can look to how the parties treated product liability claims to understand that that's how they also understood it. When you look at the schedule of the loss runs for product liability claims, the parties clearly did not understand that these repair and replacement warranty claims fell under product liability claims because they didn't include a list of those repair and replacement warranties in the product liability claims. So that's how the parties differentiated between the two. If it's a repair and replacement claim for a defective part, that's a warranty claim. We assumed that, we have liability for that. But if, on the other hand, it is a claim for bodily injury or property damage that has been caused by the product, that is what a product warranty claim or product liability claim is, and there is no assumption. Again, when we look to the overall structure of this agreement as a whole, I think it's really important to note how often the parties called out product liability claims as something to be treated different. Product liability claims are called out and treated different in paragraph 2.6. Product liability claims are called out and treated different again in paragraph 6.2. And then even in the indemnity paragraph, product liability claims are again called out and treated different. The fact that the parties throughout treated these product liability claims differently, and the fact that we can understand what the parties meant by product liability claims based on the language of 6.2, in the context of 6.2, and the schedule of the loss runs that were provided, tells us that product liability claims are treated differently and they were not among the liabilities that were expressly assumed here. Because those liabilities were not expressly assumed by the successor entity JHTNA has no liability for those claims, and the trial court correctly granted summary judgment to JHTNA on those grounds.
Any other questions? Thank you, Ms. Shout. We'll hear argument from the respondent.
May it please the court, Mr. Irwin will present an argument for the respondents.
Good morning, and may it please the court. During my time, there are two primary issues that I want to address, and then I also want to address an absurdity that if the court follows the petitioner's argument that would result. So first, why are the dissent and the petitioners wrong about whether or not implied warranties were among or within the scope, rather, of the assumed liabilities? The dissent says, and this is a quote, that the purchase agreement, quote, expressly excludes breach of implied warranty from within the scope of the assumed liabilities. Petitioners say something very similar in their brief. They say that the language of 2.5.6 indicates the assumption of product warranty claims was a narrow assumption of express written warranties. Both are wrong. Number one, the purchase agreement never expressly excludes implied warranties at all. That language isn't in there whatsoever. Nor, as the petitioners would argue, nor does the purchase agreement define written warranty as limited to express warranties contained within the written warranty. So the other problem with both of those is that what it asks the court to do is to not give full effect and meaning to all of the terms of the contract, and that's what we have to do. So we start with 2.5, as the court is aware. I've quoted 2.5 on page 2 of my brief. This is the assumption of liabilities, and it starts out saying there's a distinction in here I want to draw the court's attention to just real quickly, that we're talking about just real briefly liabilities and obligations. They use both of those words of the seller, specifically identified below, existing at, arising at the time of, or after the closing date. So a couple of just interesting things there. Liabilities and obligations, those are different words that we should construe differently. And number two, there's really, we're going to forget at the time of closing and think about two different time periods: claims that arise before, claims that arise after. All of those things are addressed in 2.5.6, which is the product warranty claim assumption of liabilities. And it starts, and I'm on page 2 of my brief, page 5 of the sealed appendix. They're assuming the liability for, quote, any product warranty claim solely with respect to, and I'm going to read the whole thing because every word is really important here, with respect to claims arising with respect to and during the time set forth in the written warranties of the seller attached here too. So the issue for the court is, do implied warranties fall within or arise with respect to the written warranties? That's the language of the purchase agreement. Well, what's a written warranty? When they say written warranty, they don't mean express warranty. They specifically say the written warranties which are attached here too. So that's an indication that when they say written warranties, they're not referring to the concept of express warranty. They're literally referring to a document that's contained, or rather attached to, the purchase agreement. So still, what does that mean? 3.1.17 tells us what these written warranties represent in plain language. And it's this, and I'm at page 2 still of my brief. That's where this language is quoted. The buyer has been furnished with complete and correct copies of, and here's the key language, the standard terms and conditions of the sale for each of the products or services of the seller, parentheses, critically important language here, containing applicable guarantee, warranty, and indemnity provisions. So what that tells us is that the written warranties, those physical documents that are attached, one of which says commercial treadmill warranty, contain all of the terms and conditions of the sale and applicable warranties. Next question is, does that include implied warranties? Because remember, nowhere in that in the exclusion of well, we'll get to that in a moment, but they haven't differentiated at all between express or implied. It just says we assume any product warranty arising out of the written warranties attached here too. We now know the written warranties mean all the terms and conditions of the sale, including applicable warranties. So what does that mean? The very next sentence indicates that the parties agreed that unless excluded by applicable law, implied warranties are part of this agreement. And there it is in a nutshell, that when you take all of the terms of this purchase agreement and you plug all of those things in, implied warranties are part of the written warranty. Therefore, if the petitioners had assumed liability for any product warranty claim arising out of the written warranty, and now we know that the written warranty includes implied warranties, then they've assumed liability for implied warranties. That's it in a nutshell. What they do is they point to what they call disclaimers in the purchase agreement as the basis for trying to exclude this claim, which is a breach of implied warranty claim, from within the scope of the assumed liabilities. The first one is 2.6. This just simply doesn't apply at all. And the reason is in the plain language of 2.6, this is the excluded liabilities. I'm on page 8 of my brief. It's page 19 in the sealed record. And I'm not going to read the whole thing. It's not that it's too long, but there's a lot of words, and I just want to focus on a couple of things. The buyer shall not assume any liabilities, obligations, there's that word again, or commitments of the seller relating to arising out of the operation of the business or ownership of the assets prior to the closing. Well, this claim arose after the closing. So this claim is not excluded based on 2.6, just based on that phrase prior to the closing. Remember, 2.5 said that we're going to address claims that arise before closing, at closing, and after closing. 2.6 only addresses claims that arose prior to closing. That's number one. Number two, 2.6 doesn't apply because whatever that disclaimer might mean is limited by the very last phrase that says, other than the assumed liabilities. So it really doesn't matter what that first part said because our claim fits within the assumed liabilities. 6.2. 6.2 is an insurance provision. 6.2, and it is important to read this one, and I apologize for reading to the court, but I'm at page 9 of my brief. This language comes from page 46 of the sealed record. Notwithstanding anything in this agreement to the contrary, nothing in this agreement or any of the transaction documents shall cause or be construed to cause the assumption of any obligation or product liability claims for the buyer. So the most obvious thing here is that it in fact does not say that they are not assuming the liability for product warranty claims. And that's what they want this court to do, is to read that paragraph to say that, and that would require that you disregard that it refers to obligations, not liabilities, and that it refers to only to product liability claims and not to product warranty claims, which are treated differently and are contained within the assumed liabilities. So that raises an interesting, a couple of things that I want to point out to the court. That's the obvious one, but simply put, the plain language of 6.2 does not apply to this situation. Here's some other things that the court might consider. So in the original, it's the amended motion for summary judgment, which is at page 47 of the clerk's record. They then filed a reply brief to my response. That's at page 80 of the clerk's record. Here's something interesting. They never once mentioned 6.2 in either of those briefs. It never comes up. The only thing they rely on is 2.6. So, and I realize they can raise contractual terms now that weren't raised. That's not the point. The point is this: why not? Here's a potential answer to that question, because the other thing that they did was they filed along with their motion. This is the sealed record, is an affidavit from Mr. Burke, who is we'll call him a corporate representative. He's got a more specific title, but we'll call him the corporate rep for these companies. And he tells us exactly what the parties intended and what they meant. And I'm at page 11 of the sealed records, and I'm going to quote him. While JHTMA, TNAM, and that's the subsidiary that actually was purchasing Magnum, agreed to assume certain product warranty claims in section 2.5.6, which we already know, none of the liabilities identified in section 2.5 include products liability or torts claims for products sold before the consummation of the agreement. In fact, the agreement specifically disclaims liability for such claims, and we're referring to tort claims and product liability claims, in section 2.6. That's it. That's the only section that the company actually pointed to as the basis for disclaiming any potential liability for claims like this one. And we already know that 2.6 simply doesn't apply because it refers to claims that arose before the closing. That's not ours. And then it was limited by the language of other than the assumed liabilities, and that's ours.
Mr. Irwin, can I just ask you, is there any insurance secured under paragraph 6.2 that covers this claim, even though there's no property damage claim? How does that work?
Well, that's exactly where I was getting ready to go. So why is that? To answer your question directly, I do not know whether or not there's any insurance. Whether or not there is outside the record in the case. I can tell you because I know they've never produced any insurance policies so that I'm aware of. So I don't know the answer to that. And so I can't answer, does the insurance policy itself only insure claims that are both have a personal injury element and a property damage element? I can't answer that. I don't know. But therein lies the interesting issue because one of the reasons, and I think probably, I think there's a couple of reasons why the companies didn't point to this provision early on. The first is the obvious reason is it doesn't disclaim liability for product warranty claims. What it does is distance them from obligation for product liability claims, very different. But the other thing is that this is an insurance paragraph. We're in part 6 of the agreement. We're a long way from 2.5, which dealt with assumed liabilities, 2.6, which dealt with excluded liabilities. We're now in part 6, which deals with what the agreement calls employees and other agreements. And that other agreement in 6.2 is the agreement to provide this product liability insurance.
But don't we still have to construe, though, all of these provisions together? And so that's where I'm struggling a little bit.
Yes, yes. So number one, I think that this language really was an effort to stave off, if you will, the potential issue in insurance coverage where you might be contractually assuming the obligation for someone else's liability, similar to what this court addressed in the Gilbert, Texas Corporation v. Underwriters at Lloyd's of London. And it's a familiar provision under any kind of CGL policy where frequently there's an exclusion that says, if you've contractually obligated yourself to pay for someone else's liability, that might be an exclusion. Honestly, I think that's what they were trying to address here. The other thing is this, to get directly to your issue, how do we put these things together so that we don't defeat the purpose of either term? And I think that's an easy solution, that overall, this contract, this purchase agreement excludes the assumption of liability for product liability claims. Keep in mind, in our original petition, we sued for negligence, the strict liability, all the standard things that somebody would sue for. So overall, it excluded liability for those things, but then carved out an exception for product warranty claims. And that's entirely consistent with the way that this agreement was written, because they specifically treat those two things very differently. And I would point out that they capitalize. I'm not much into it. People capitalize things and it means nothing. But in this case, so they capitalize product liability claim. And I know that the Court of Appeals drove into how that was defined. And it is the way it was defined. They did do that. And whether or not that's reasonable, I would suggest to the court that if the court thinks that that was not a reasonable interpretation, that rather the reasonable interpretation would be to read the and as an or, that creates two reasonable interpretations, which creates a fact issue, which precluded summary judgment in the first place. This wasn't an issue that was raised in the court below, so we couldn't address that. But the other issue is that, this is where I was going with the product liability claim. So what the petitioners point to try to say, well, surely we meant, surely the parties meant rather, claims that were for bodily injury only as product liability claims, and they refer to a schedule contained in the agreement. That's at 3.1.17b. And a couple of things. First of all, notice that when they refer to the quote complete list of product liability claims, we're now lowercase product liability claims in the same paragraph. And in fact, well, the very next sentence refers to the capital P product liability claims. So there's a distinction, I think, being made between capital P product liability claims and not capital P product liability claims. More important, and this is far more important, that the entire argument that this list, this schedule of claims only dealt with one or the other and not both is simply outside the record. There's nothing that the petitioner can point to that actually establishes that. When you read the list of claims, first of all, in the petitioner's brief on page 10, they omit a good number of the claims to support their premise. There's at least 7 that they don't mention, where you can't really tell what the complaint was. Was it a property damage? Was it property and personal injury? You can't tell. There's things like it just says claimant alleges product defect, or tender of claim by Jim, or claimant alleges weight machine was defective, or equipment tipped over. That tells you nothing about the nature of those claims or whether or not they involved both a personal injury element and a property damage element. And that entire argument is completely outside the record, and it's asking the court to make an assumption and an inference that they're not entitled to, that I'm entitled to. I'm entitled to the inference that it doesn't support that. And that's what I would say about that. So back to your question, which was how do we mesh these things together? We mesh them together in the way that this contract did, which is saying that there's an overall scheme of we're not assuming, or rather within the scope of our assumed liabilities, we're excluding product liability claims, but we're carving out an exception for product warranty claims. And we've seen under the product warranty claim analysis how they cannot separate the implied warranty from the written warranty. Which
is there a definition anywhere in the agreement of the capitalized term product warranty claim?
I forgot to mention that. Product warranty claim is not defined anywhere in the agreement. I would suggest that the plain language, the plain meaning, that how could anyone argue that that wouldn't include both express and implied? That what the petitioners have insisted is that that language excludes implied warranties, and it just simply does not do that at all. It's not defined anywhere, and I think it would be a reasonable interpretation giving fair meaning to that phrase to define it as including both implied and express. Finally, absurd result. If you follow the petitioner's line of reasoning, it goes like this. Keep in mind, in the Court of Appeals below, they conceded that they had not disclaimed the implied warranty under Texas or Wisconsin law. So it's there, all right? And here's what their argument was. Their argument was, okay, yes, as we know, the implied warranty is imported into the agreement, which means, as this court has told us, that means that the implied warranty is every bit as much a part of the written agreement as the express terms. But somehow, miraculously, it does not attach or import into the written warranty. Think about that for a moment. What that literally means is that, okay, we agree that they want this court to rule it was imported into page 1 of the agreement, but not page 2, not the attachment. That's what's absurd. That makes no sense whatsoever. The right outcome, and the Court of Appeals got it right, is that these provisions, the implied warranties, are gap fillers. The Court of Appeals went into some Wisconsin law, though the court didn't need to do that. That's well-known Texas Supreme Court law as well, that implied warranties are gap fillers, and you cannot separate them from the written warranties, which, remember, were defined as containing applicable warranties. And with that, I appreciate your time.
Any other questions? Thank you, Mr. Irwin. Ms. Scott, I believe you have 5 minutes.
Your Honors, I would just like to briefly address the idea that the concept that, well, you didn't expressly exclude the implied warranty of merchantability. The question in successor liability cases is not what we expressly excluded, it's what we expressly assumed. And when we look at what we expressly assumed, we're looking at paragraph 2.5, and the question is raised, well, was product warranty claim defined? And there's not a specific separate written definition in the definition section for product warranty claim. But product warranty claim has to be understood in light of the language in 2.5.6. 2.5.6 tells us what a product warranty claim is. A product warranty claim is solely with respect to claims arising with respect to and during those time periods set forth in the written warranties.
But can an implied warranty, though, arise without an express or a written warranty?
It can arise. It can arise without an express or written warranty. So you could have a situation where there were no express written warranties, and the only thing implied in the terms of sale would be an implied warranty. That's possible, but that's not what's assumed here. The liability that's assumed here is only claims with respect to and during those time periods set forth in the written warranties. And when we go look at those written warranties, we see the time periods set forth are for specific repair and replacement obligations for defective products.
Don't you have to look at the written warranties to know, don't you have to look at the express written warranties to know the scope of the implied warranties? And if that's true, then wouldn't the implied warranties arise with respect to the written warranties?
No, Your Honor, I don't think you have to look at the written warranty to know the scope of the implied warranties. One of the arguments
I thought the law on that was that if the written warranty, the express warranty can displace the implied warranty if it's specific enough in doing that, right?
Yes, so it could disclaim or modify the implied warranty. Yes,
Okay.
it could do that. But here, the terms and conditions, one of the things that Mr. Irwin said was that that this written warranty includes all the terms and conditions of sale. And so it's the only place for the implied warranty to land. It's the only place for it to be inserted. That's not the case. If you look at Exhibit 2 to the motion for summary judgment, which is in the sealed record, that's the purchase order for this treadmill. And the purchase order for the treadmill indicates that it has terms and conditions. That's part of the contract too. The implied warranty is implied into that contract for sale. It's not implied into these express warranties. And I think the other thing—
What's your response to his argument that you disclaimed all obligations for product liability claims, but you should have said all liability for product liability claims, and that makes a difference?
I don't think there's a difference between liabilities and obligations. I did some looking to try to get a grasp on what's the difference between a liability and an obligation. And as the best I can come up with, an obligation is a responsibility under a contract. And a liability almost seems to be more of like a judgment on the back end for that obligation. I know that's not particularly helpful, but that's the best thing I can come up with because I really don't think there's a difference between the terms. Beyond that, paragraph 2.6 says that we exclude any liability relating to product liability claims. And so it's any liability there. product liability claims are defined broadly. It's both property damage and bodily injury. And when we look at this overall context here, the fact that they call out product liability claims over and over as something to be treated differently, to give meaning and intent to that language, you have to treat them different from product warranty claims. And the easiest way for that to happen, where all these terms are still given effect, is when product warranty claims are limited in connection with the language of 2.5.6 to those express written warranties that are given. If you limit it that way, the rest of these kind of inconsistencies that are pointed out fall away. Thank you.
Any other questions? Thank you, Ms. Shout. The case is submitted and the clerk will adjourn the court.
Oh, yay, oh, yay, oh, yay. The Honorable, the Supreme Court of Texas now stands adjourned.
Casey?
We're still live, Casey.